Good evening. I am Pastor Bob Uzzle from the Bethel African Methodist Episcopal Church, Corsicana, Texas. Today is June 29th, 2020. I hope everybody is having a good day. There's an interesting event that is going on right now called Starving for Justice. It's available on Facebook and probably will eventually be available on YouTube. It today marked the 48th anniversary of a decision of the United States Supreme Court, Furman v. Georgia, on June the 29th, 1972. 48 years ago today. And I remember when the decision was handed down and the controversy surrounding it and false hopes that it generated. This was a criminal case that for the time being invalidated all death penalty schemes in the United States. And when I was attending University of Texas at Arlington, working on a master's degree in political science, I took a seminar on the death penalty in which the entire semester was devoted to only that topic, and we read a lot of different Supreme Court cases. The first was Furman v. Georgia, which is over 100 pages long. There's 9 justices on the Supreme Court, and not everyone writes an opinion in every case, but this was one in which they did. It was a 5-4 decision in which you had the opinion written for the court, the majority opinion, 5 concurring opinions, and 4 dissenting opinions. So that is rather unusual. And it's interesting to me that the 5 justices that voted to strike down the death penalty had all served under Chief Justice Earl Warren, who had retired in 1969. The 4 dissenting justices had been appointed to the court by Richard Nixon. Now keep in mind, this case did not declare that capital punishment per se was unconstitutional. It did declare that it was unconstitutional the way it was being administered at the time. It mandated a degree of consistency in the application of the death penalty and resulted in a de facto moratorium on executions in the U.S. It ended when the case of Gregg versus Georgia, 4 years later, agreed to allow the death penalty again. And sometimes you hear the term post-Furman executions. That means any that have been occurred since 1972 when the Furman decision was handed down. The Supreme Court consolidated the cases of Jackson versus Georgia and Branch versus Texas with the Furman decision, thereby invalidating the death penalty for rape. Thus, ruling was confirmed post-Gregg in Coker versus Georgia. The court had also intended to include the case of Akins versus California, but between the time of Akins had been heard oral argument, decision was to be issued. The Supreme Court decided in California versus Anderson the death penalty violated the state constitution. Akins was therefore dismissed as moot, since the decision reduced all death sentences in California to life imprisonment. Now, In Furman versus Georgia, the resident awoke in the middle of the night when William Henry Furman found him committing burglary in his house. At trial, in an unsworn statement allowed by Georgia criminal procedure, Furman said that while trying to escape, he tripped and the weapon he was carrying fired accidentally, killing the victim. This contradicted the prior statement to police that he had turned and fired a shot blindly while fleeing. In either event, because the shooting occurred during the commission of a felony, Furman would have been guilty of murder and eligible for the death penalty under then extant state law. Furman was tried for murder and was found guilty based largely on his own statement. Although he was sentenced to death, the punishment was never carried out. And in this 5-4 decision, the court's one paragraph per curiam opinion held the imposition of the death penalty in those cases constituted cruel and unusual punishment and violated the Constitution. But not all the justices agreed on every particular. Justices Thurgood Marshall and William Brennan were the only two abolitionists on the court. They both held the opinion that capital punishment was in all cases cruel and unusual punishment. They were joined in striking down the laws by Justices Potter Stewart, Byron White, and William O. Douglas, all of whom expressed the opinion that under the right circumstances, capital punishment might be constitutional. But they were very concerned about racial bias against black defendants. And because these opinions were the narrowest, finding only that the death penalty, as currently applied, was cruel and unusual, the Alford considered the controlling majority opinions. And Justice Potter Stewart wrote, "These death sentences are cruel and unusual, in the same way that being struck by lightning is cruel and unusual. For of all the people convicted of rapes and murders in 1967 and 68, many just as reprehensible as these, the petitioners, are among a capriciously selected random handful upon which the death penalty has in fact been opposed." And there's no question about bias in sentencing. It's been stated very truly that he who lacks the capital is the one who gets the punishment. And often it's not for the worst crime, but for the worst lawyer. And both Brennan and Marshall concluded the death penalty was in itself cruel and unusual punishment, incompatible with the evolving standards of decency of a contemporary society. Now, Chief Justice Warren Burger, Justice Harry Blackmun, and Lewis F. Powell and William Rehnquist, each appointed by Richard Nixon, wrote dissenting opinions. They argued that a punishment provided in 40 states at the time by the federal government could not be ruled contrary to so-called evolving standards of decency. And it's interesting about one of these justices, Harry Blackmun, throughout much of his career was a strong supporter of the death penalty. However, toward the end of his life, he had second thoughts about it. And he said he'd worked for years trying to make the system fair, trying to make it work and be equitable to all concerned. He finally threw up his hands and he said, "I will never again tinker with the machinery of death." In an exam at UTA, I had made the statement that Justice Blackmun had joined the abolitionists, and my teacher questioned that, saying that Justice Blackmun never actually said the death penalty was unconstitutional. he did say it was unworkable. And so I guess depending on how you define the term abolition. But when he retired shortly after that, but he predicted that future generations would abandon the practice completely. The Furman decision called all death sentences pending at the time to be reduced to life imprisonment. The next day, columnist Barry Swide wrote that it was unlikely the death penalty could exist anymore in the United States. Unfortunately, these are famous last words. And the Supreme Court decision forced states and the U.S. Congress to reconsider their statutes for capital offenses to ensure the death penalty would not be administered in a capricious or discriminatory manner. And during the next 4 years, 37 states enacted new death penalty laws intended to overcome the court's concerns about arbitrary imposition of the death penalty. It's my understanding it was during the summer of 1973 when I was working in Virginia that my home state of Texas reinstated the death penalty. It would be another 9 years before they carried out. But several statutes that mandated bifurcated trials. In other words, they can't just have one phase of a trial. You have to have two phases. Phase one, you consider guilty or not guilty. Obviously, if a person is not guilty, that's where it ends. But if a person is found guilty, then you have to have phase two, in which they'll consider punishment, and they must take in consideration aggravating and mitigating factors. Aggravating factors make it worse. Mitigating factors make it not as bad. And so the states that wanted to hold on to it, they rewrote their laws to try to meet constitutional standards. And on July 2nd, 1976, in Gregg versus Georgia, these standards were upheld. And so the term post-Furman is what's often used. In Texas, there was no executions between 1964, the last time the electric chair was used, until 1982 when lethal injection was introduced. And even in Texas, the numbers come down. One of the reasons, but not the only reason, since September 1st of 2005, the juries now have an option of sentencing people to life imprisonment without parole. And so the number of new death sentences and the new executions has come down. Of course, the pandemic is definitely having an effect on that. But if you have a chance, look at the Starving for Justice, which today is the 48th anniversary of Furman versus Georgia. On July 2nd, which is Thursday, will be the 44th anniversary of Gregg versus Georgia. Many of us are praying and fasting for at least part of the day and regarding these grave matters. And so anyway, this is a very important issue that we need to be well aware of. Have a great evening, and God bless you.